welcome back everybody. This is Mike Riley, and in today's video, I'm gonna talk about testifying in court. Sometimes you could choose to testify in court, and sometimes you're compelled to testify in court. In today's video, you can expect to learn what a subpoena is, what it means to be subpoenaed, whether you should decide to testify on your own behalf or exercise your right to remain silent, and if you do choose to testify, we're gonna go over some practical advice to make you be the best witness you can be in court. So like I said at the beginning of the video, sometimes you get to choose to testify in court, sometimes you're compelled or forced to testify in court, and I want to talk about that first. Someone is forced or compelled to testify in court when they are subpoenaed. A subpoena is a court order, a document compelling somebody to come to court. It's an order. You have to show up on such and such a date at a certain time and answer questions under oath. It's an uncomfortable situation, but it is a court order and there are consequences if you choose to ignore it. So first, what happens if you ignore the subpoena altogether and decide, I'm just not going to go to court? I don't care if I'm being ordered to go to court. I've seen victims of crime subpoenaed to come to court and they've chosen for whatever reason to blow off the court date. I have then seen a prosecutor ask a judge to issue what's called a capias, which is basically a warrant to go arrest that person and bring them into court in cuffs. Now, the person is not being charged with a crime, but they are taken into custody and presented in court to testify. I have not seen this tool used often, but I have seen it used in some of the more serious cases, particularly homicide cases, where the state's interest in bringing forward the witnesses and prosecuting somebody is perhaps a little bit higher than, let's say, a shoplifting case. So then the next question is, okay, if I'm subpoenaed, I'll come to court, but I'm not saying anything on the stand. I'm gonna sit there with my mouth closed and nobody's gonna force me to answer any questions. If you refuse to answer any questions when you've been subpoenaed, a judge can hold you in contempt of court. This is a mechanism by which a judge can fine you or even put you in jail for failing to comply with a subpoena. There are also other issues that come up if a witness is compelled to testify and they decide to take the Fifth. And I'm gonna do a separate video on this, exploring specifically Fifth Amendment issues, immunity, and other topics like that, so you could stay tuned for that. So when I subpoena somebody, they will usually call me and say, what is this? I don't wanna come to court. I've got work, I've got other things to do. And I will explain to that witness why I'm subpoenaing them, what kind of testimony I expect them to give at court, and I'll give them an idea of whether or not I'm actually gonna need them. Depending on how a case goes, sometimes you might end up not needing a witness that you thought you would, and you can release them from the subpoena. So that's subpoenas. That's when you're compelled to come to court. There's certainly less wiggle room in that situation, right? It's a court order. You have to go, and there's consequences if you don't. A more difficult decision is whether or not you should testify on your own behalf if you are going to trial. And I'm talking in a criminal court context here, okay? So if you're charged with a crime, you're going to trial, you need to decide whether you're going to testify or whether you're not. Now, generally speaking, all strategic decisions at trial are up to your lawyer. Your lawyer gets to decide how to go attack the case, what evidence to put on, what witnesses to call. Whether you decide to testify or not in court is solely up to you. Your lawyer cannot make this decision for you. You're the only one who can decide whether you're going to exercise your constitutional right, present a defense and testify on your own behalf, or exercise your Fifth Amendment right and remain silent as to the charges against you. Now, obviously, your lawyer is there to counsel you throughout the process, and I will generally give my clients my own 2 cents on this issue. Hey, listen, I don't think you should testify. I think you're gonna get ripped up. Or, hey, the only way we're gonna get through this is if you get up there and put on a defense and testify on your own behalf. So first, let's talk about what happens if you don't testify. You have a right to remain silent. You have a right to not talk. You have a right to not get up on the witness stand and not be subject to cross-examination. And that's the major reason why someone's going to opt out of testifying. As a defense attorney, it is my greatest concern for my clients that they're going to get killed on cross-examination. And even if we had a chance at winning a trial, they're not going to be able to get through cross-examination by a seasoned prosecutor, and it's going to hurt us dramatically. So a lot of the times, a lot of defense attorneys tend not to have their clients testify. And this is a case-by-case basis. There is no general rule. There is no, hey, most of the time you should not testify. The lawyer needs to go through the case and make a recommendation to the client. I think you need to testify here, or the potential benefits do not outweigh the risks presented by cross-examination. If you choose not to testify, it is your constitutional right. It cannot be held against you. But still, there might be a natural inclination among jurors to wonder, why is this person not testifying? Why are they not getting up there and telling me their side of the story? I needed to hear that in order to give a fair verdict in this case. And this is something that lawyers explore during jury selection. One of my standard questions in jury selection is I ask any juror, the judge told you earlier that my client has an absolute constitutional right not to testify. How would you feel if the client did not testify in court? And it's important to ask follow-up questions. In a murder case, I'll ask somebody, say, my client is charged with murder. Do you think when his life is on the line, when he's charged with murder, does that change the way you look at it? Do you think in that situation, he really needs to testify on his own behalf? And you get a variety of answers. Some jurors will say, listen, I understand he has a right not to testify. I'm not going to hold it against him. Other jurors will answer candidly, listen, I can't promise you that I'm not going to have a problem with that. And if a juror says that, a potential juror says that they can't commit to following an instruction not to draw any negative inference from a defendant's election not to testify, that person can be stricken from a jury for cause. The decision to testify involves a cost-benefit analysis. You have to weigh the cost of going through cross-examination, of going through the ringer, against the benefits you might potentially get by testifying. As a defense attorney, when I'm trying to make a recommendation to my client as to whether or not they should testify, I look at what I need to argue in my closing argument. Can I get all the facts into evidence that I want to argue at closing without putting my client on the stand? Or do I need my client to get up there and fill in some other gap? So for example, let's say it's a self-defense case and I want to argue at closing that the victim was armed, that the victim was much bigger than my client, and that the victim was the initial aggressor, started it with my client. Now, if I can get those facts in through other witnesses, the need to put my client on the stand is diminished, right? So now the risk of cross-examination is greater and the benefit is less because I'm going to be able to argue all of those facts because they're coming in through other witnesses, other evidence, perhaps surveillance, photographs, things like that. However, there is still an argument that putting your client on the stand humanizes them. The jury gets to see them as a human, not just a silent person sitting there in the courtroom. They get a feel for them. They get to hear the way they talk. They get to hear about them a little bit, maybe a little bit of background, and it's going to humanize your client, and a jury's more likely to have empathy for that person, connect with them, and maybe be a little less likely to convict them of a crime. But again, I'm going to say it a million times, cross-examination is a serious hurdle. You want to avoid having your client cross-examined whenever you can. Cross-examination is dangerous. Cross-examination is being subject to questioning by your adversary. A prosecutor in cross-examination is most likely going to try and destroy your client's credibility and suggest that they're not truthful and a jury cannot believe their testimony. They'll bring up the fact that it is essentially self-serving testimony, that the client who testifies on his own behalf has more of an interest in the outcome of the case than probably anybody else. So a prosecutor is going to get up there and try and suggest that they're giving self-serving testimony, that they're just trying to get themselves out of trouble. A prosecutor could confront your client with any variety of things to impeach their credibility. I recently had a client who is a heavy social media poster, and the prosecutors had every single post ready to go. They had studied his videos, studied his posts, and they were ready to catch him into a lie and confront him with things. Things can be taken out of context, things can be spun, turned around on you, and it can blow up in your face. People need to think long and hard before deciding to testify. I've seen some people do beautifully and really come out ahead by virtue of their decision to testify, but you really need to be prepared. You need to know what's coming. Your lawyer needs to work with you, go through mock cross-examinations, get you ready for what you're likely to endure on the stand, and in that situation, I think you have a better chance of coming out in one piece. If you do decide to testify on your own behalf, there's a few things you should keep in mind. Number one, tell the truth. Do not get up on the stand and lie. And there's several reasons why you should always tell the truth on the stand. Number one, it is a crime to lie under oath. This is perjury. So if you get up on the stand and you lie under oath, you might not only be opening yourself up to getting cross-examined on a lie, but you could be creating more legal problems for yourself by getting yourself a new case where you're charged with perjury. Always tell the truth on the stand. There's an old saying that an honest man has nothing to fear, and these should be words that guide you when you're testifying on your own behalf at trial. Be an active listener when you're testifying at trial. Listen carefully to the question that you are being asked before you answer. Do not give knee-jerk answers to questions. Pause, digest the question. Think about what are you actually being asked and then give an answer slowly and carefully. You could help control the pace of cross-examination by taking this pause. A lawyer who's cross-examining you at trial might want to keep the pressure on you, keep these questions coming rapid fire. You can disrupt the lawyer's ability to do that by taking control of the pace. Take a deep breath. Think for a second. Go slowly. Only answer what was asked. So when I'm preparing a client to testify, I will generally go through these rules and then I will stop at one point and say to the client, by the way, do you know what time it is? 95% of clients will then look at the watch and say, yeah, it's 3 o'clock or it's 4 o'clock, whatever it is. That's not what I asked. I asked if you knew what time it is. I'm asking if you have knowledge of the time. I did not ask what time is it. These are different questions, okay? And your lawyer is going to prepare you to see these nuances. Take a second, digest the question, formulate your answer, and give it succinctly. Getting through cross-examination is not easy. If you are being cross-examined and it starts going south, you're getting beat up on the stand, don't stare at your lawyer like with these eyes wide open, like help me, save me. Your lawyer is going to jump in and object when he or she can. But cross-examination, you're subject to it. You're up there on the stand, you've got to answer these questions, and your lawyer is going to jump in when they can, but if they can't, they can. You got to get through it. And it could go on for hours. It could be a lengthy process. Eventually it will end. Cases are often won or lost based on someone's testimony at court. Do I prefer to have my clients testify or not? Honestly, if I can make the arguments that I want to make at closing without putting my client up there to go through the grinder of cross-examination, I'm going to encourage them not to testify. But again, that's not my decision. It's the client's decision, and my job is to back them up, whatever their decision is. So what do you think? If you were charged with a crime, would you testify on your own behalf? Do you think you could get through a cross-examination? What are some of the things that you would do to help you get through cross-examination in one piece? Please let me know your comments. I'd love to hear your thoughts. I appreciate all of your support. Thank you so much for watching.